The Jack Daniels case was the most closely watched trademark case in decades because of its potential impact on the right to use trademarks in expressive ways. This video is just going to summarize the case and its outcome. Later videos in the series, if I get around to them, will talk about some of the deeper trademark law questions surrounding the Jack Daniels case. Let's start with the background. VIP Products makes dog chew toys under the Silly Squeakers brand. Examples include things like Blue Cat's Trippin', Mountain Drool, Heiny Sniffin', and of course, Bad Spaniels. And so you can see the joke, right? So Tennessee whiskey is replaced with Tennessee carpet, 40% alcohol becomes 40% poo by volume, and it's 100% smelly. Fun stuff. And of course, you can see the similarities in the design of the two products. I can also confirm that the chew toy squeaks really loudly. So Jack Daniels isn't amused, and they tell VIP to stop. VIP says no, and they end up in court. Jack Daniels wins at trial. The judge rules that the Bad Spaniels toy infringes the Jack Daniels trade dress because it is likely to confuse consumers. Now, in the trial, the court gave a lot of weight to a survey by Jack Daniels that purported to show that a substantial number of consumers were likely to be confused about whether Jack Daniels was the source of the toy or, critically, was somehow affiliated with VIP or gave it permission to make the toy. The judge also decided that the chew toy is likely to dilute the Jack Daniels marks because associations with poop are likely to tarnish them. And of course, all of these conclusions about likelihood of confusion are very contestable and worthy of discussion, but let's just stick with what the district court did and what the next step was. So VIP appeals to the Ninth Circuit Court of Appeals, where they win. The court throws out the dilution by tarnishment claim by Jack Daniels because the dilution statute excludes liability for, quote, non-commercial uses. Even though the toy was sold in commerce, it has an inherently non-commercial component. It's making fun of Jack Daniels whiskey. Given that, according to the court, no dilution claim was possible. The Ninth Circuit also ruled against Jack Daniels on the trademark infringement question, saying that the district court should have applied what is called the Rogers test to the infringement claims because the chew toy, quote, although surely not the equivalent of the Mona Lisa, is an expressive work, unquote. So that takes us to the Rogers test. The Rogers test comes from the case Rogers versus Grimaldi, and it's how many courts used to evaluate trademark infringement claims when the defendant was making an expressive or artistic use of the plaintiff's trademark. For example, by making paintings of famous Alabama football games. The paintings may depict Alabama trademarks, but the depictions themselves are artistic and worthy of protection. Now, that raises the question of why a special test was seen as necessary by some courts. Normally, trademark infringement claims are evaluated under a multi-factor test that, under usual circumstances, makes no special allowances for a defendant's First Amendment rights. And in an ordinary trademark case, there's no real need to. There doesn't seem to be a big First Amendment question with telling me I can't market my soda under the name Coca-Cola or Coca-Cola or Coda-Cola if it would confuse consumers about the source of the soda. I can use some other kind of mark. I can call it, for example, Eagle. But things are different if I want to talk about Coca-Cola or make a movie about Coca-Cola. Over time, trademark law expanded to the point that trademark holders felt like they had room to bring trademark infringement claims against references to their marks that were expressive or artistic. Now courts had a stronger sense that the free expression interests of defendants were at stake in a way that they maybe weren't before. And moreover, that the existing multi-factor test wasn't designed to take these interests into account. The Rogers test is one response, and it has been adopted by federal courts in most of the country. A court applying Rogers asks first if the defendant's use of the mark is artistically relevant to the defendant's larger work. If the answer is yes, then the court asks whether the defendant does anything explicitly misleading regarding its relationship to the trademark holder. That's the test that the Ninth Circuit wanted the district court to apply in Jack Daniels, and when it did, VIP won easily. On the first prong, the district court noted that the toy imitates yet alters the Jack Daniels trade dress to make a joke about a dog defecating on the carpet. Given that, the trade dress is relevant, if not central, to VIP's message. As for the second prong, VIP did not explicitly mislead about a connection between its goods and Jack Daniels. The infringement claim therefore had to fail. So Jack Daniels appeals its way to the Supreme Court, which granted cert on both the infringement and dilution questions. This case received a lot of attention, as the Supreme Court has never before taken up the question of the Rogers test, and Jack Daniels wanted to get the court to discard the test altogether. Now that would have been a big deal, given the range of expressive activities Rogers has been used to protect. Songs like Barbie Girl, paintings of Alabama football, or the subject of the original Rogers litigation, the title of a Fellini film. But the Supreme Court stopped short of doing that. In a unanimous opinion by Justice Kagan, the court left the Rogers test alone for the most part, but it said that Rogers should not apply to this case. Now, why is that? The court said that while Rogers may be relevant to expressive use cases in general, it cannot be used when the defendant is using the plaintiff's trademark as a mark. Now, in the court's view, VIP was doing more than just engaging in a creative act. The design was not just functioning as a toy, it was also functioning as a trademark. That is, the court saw the Bad Daniels design as identifying and distinguishing the source of a good in the marketplace. That's what a trademark does. This is in contrast, said the court, to the examples I listed above, and the court explicitly distinguished earlier cases involving the song Barbie Girl, paintings of Alabama football, and the movie title Fred and Ginger. They all remain good law, at least for now. But the court sees the Bad Spaniels design as source identifying, as acting like a trademark. Given that, said the court, the right analysis is not a special test like Rogers, but rather the ordinary multi-factor test used in everyday trademark cases. Now, to be sure, the court said that courts considering the question of likelihood of confusion can consider the parodic nature of a use in applying the infringement test. The court cited the Louis Vuitton case, in which the Fourth Circuit also looked at a dog chew toy and concluded that it did not infringe the trademarks of Louis Vuitton. That court did not apply Rogers, but reached its conclusion by applying the multi-factor test in a way that considered the parodic nature of the dog toy. The Jack Daniels court says the same kind of thing can be done in future cases. The second of Jack Daniels' holdings concerned the non-commercial use defense against dilution actions. Here, the court was even less expansive. It ruled that whatever the general meaning of non-commercial use as an exclusion in the dilution provisions of the Lanham Act, that exclusion does not shield parody or other commentary when its use of a mark is similarly source identifying. So that's the relatively narrow result of Jack Daniels. Not as big a deal, at least for now, as some feared it might be, but certainly not nothing. And to get there, the court had the opportunity to consider, or not, some fundamental issues in trademark law raised by the case. Later videos in this series will explore some of them. Thanks for watching.